Likevel kan næriøyene på Afrikas fastland lære Europa sine egne kortsiktige interesser gå foran prinsipper om menneskerettighet og fred. Velkommen til SANDFAST, vår podkast om Vest-Sahara, den siste kolonien på det afrikanske kontinent. Welcome to the second part of the episode with Manuel Devers, and we will continue talking about the court decision. So at 2016 was to actually make things clear, especially the status of Western Sahara, and then the second one was about more technical, like if Polisario. Yeah, could you say more about that?
Yeah, regarding the new cases. So the thing that, as I said, the law was very clear, but there was a very cynical calculation from the EU, and in two senses. The first one is that when you start litigation, you are actually bearing the risk of litigation. You know, you can miss a deadline, or something can happen, and the case does not go through. And I must say that was 90% of the job that were done in 2016, but the 10 remaining % were still a lot of work, because basically the Commission and the Council were really trying to push the General Court to change the case law of the European Court of Justice. And so we had extensive discussions on the right to self-determination, international humanitarian law, the law of occupation, to explain that actually the 2016 ruling is really perfectly in line with broader considerations of international law. The second thing that went really unnoticed, and that is equally cynical, but for the Moroccan governments, and there, just a small party, I want to make something very clear. In our work, we always made the difference between the people of Morocco and the Moroccan authorities. And the failure of the case and the defeat that was received in the last Wednesday, so the 29th of September, is the defeat of the Moroccan authorities. There is no way out of Western Sahara without the right to self-determination of the Sahara people. That must be clear. But the trap, and that's something on which I want to insist. So after 2016, the court says no agreement applicable to Western Sahara without the consent, and because of the separate status, an explicit extension, if you want. The fact is that if you need to extend existing agreement between Morocco and the EU to Western Sahara, that's precisely because Western Sahara is not Morocco. If you take, for instance, an agreement concluded by Italy, all agreements concluded by Italy includes Sardinia, because Sardinia is a part of the Italian territory. Yeah. And so the trap that was made by the Commission on the Moroccan authorities is that they forced the Moroccan authorities to accept in an international agreement that an explicit extension was necessary, so that basically the Moroccan authorities recognize that in their relation with the EU, they don't have sovereignty over Western Sahara. And that's something that is a bit technical, but that is, has to be put in the broader context of the Trump Declaration. The Trump Declaration is just a political statement based on EU law, on US law, whereas the extension agreement is an agreement, not a political declaration, based on international law. And by that agreement, Morocco, the Moroccan authorities, recognize that Morocco has no sovereignty over Western Sahara.
Yeah, and I mean, the Commission, they could save themselves so much time and save you so much time if they just respected actually the decision from 2016. So it's clear that Western Sahara is not a part of Morocco, and I'm speaking about the decision of the court. And then there is that we need the consent of the people. But Manuel, some Norwegian companies, for example, in the occupied territories, claim that operating there, like in the occupied territories of Western Sahara, is okay because it provides kind of benefits to the local population, and the benefit was mentioned in the court.
That's why all that narrative, on the benefit collapse.
Yeah,
that's clear that you need that the Sahrawi people have the right to self-determination and independence. They are the owners of their territory, of their natural resources. And so the only question to ask is whether you got the consent from the Sahrawi people through an authorization by the Polisario Front. If you don't have it, don't talk about benefits. That's totally irrelevant. And something that I need to add maybe on the ruling of last September is that in 2016 the court set up the framework, but since the agreement was not applicable to Western Sahara, it declared the application of the Polisario Front inadmissible, because basically the Polisario Front and the Sahrawi people, they have no interest to challenge an agreement that is not applicable to Western Sahara.
Yeah.
With explicit extension, that changes. The agreement is touching Western Sahara, is touching upon the natural resources of Western Sahara. So the Sahrawi people are concerned, because this is their land, their natural resources. And there, what is really another breakthrough of the ruling is that the General Court recognized that the Polisario Front is the sole representative of the Sahrawi people on the international plan. And so that therefore, the Polisario Front is able to go to court to defend the rights of the Sahrawi people in every aspect that I mentioned. So natural resources, the territorial components, the national unity, the political process also. And the court even developed an argument that is really powerful to say that the Sahrawi people have rights under international law that have been recognized by the court in 2016. They need an access to the EU judicial system.
Yeah.
And the only way for the Sahrawi people to have an access to court is through the Polisario Front. So you can really say that the Sahrawi people are now under the protection of the European Court of Justice. And those companies that are now implicated in the occupation of Western Sahara, that is an unlawful occupation, and many war crimes that are committing there, we're saying be careful, because the standing of the Polisario Front before your courts equally applies before domestic courts.
Yeah.
So the Polisario Front now would be able to go before Norwegian court or German court or other courts to enforce the right of the Sahrawi people at the domestic level.
That's amazing, because that was not in the previous decisions. So how do you think, Manuel, how should the EU comply with the court ruling? Because, I mean, we saw that they didn't care. So how do you think they should comply with this ruling now?
Actually, in your questions, there are two questions. How they should comply, and actually whether they will comply or not. Right. As you said, from 2016, the ruling was very, very clear, and the Commission always trying to find a way to circumvent the ruling. We followed the entire process of the renegotiation of the agreements, and that was extremely violent to the Sahrawi people. They really tried to, through that consultation process, to create divisions between the Sahrawis, to give them a little something so that some groups would participate. And I would really like to emphasize the strength of the Sahrawi people that did not get divided, despite the attempt of the Commission, that all the Sahrawi people and the NGOs said the same thing. If you want to have an agreement applicable to Western Sahara, go to the Polisario Front. So my point is, the Sahrawi people actually were brave enough to get back to court, and they enforced the rule of law at the EU level. And I think that's a powerful message. That also shows that the Commission is capable of anything. So will they obey the ruling of the court? We don't know. We have the means to force them to obey the ruling of the court by initiating new cases, like cases regarding the compensation that should be paid to the Sahrawi people for the wrongful applications of the EU agreement to occupy Western Sahara. Now, on how the Commission should comply with the rulings, well, the answer is, in a sense, simple. It should develop an entire policy across all EU law fields to differentiate between Western Sahara and Morocco, as to ensure that when it deals with Morocco, it does not deal with Western Sahara. That's what we call the policy of differentiation, and that actually the Commission developed in the case of Palestine. And so in the case of Palestine, the Commission adopted technical measures through legislation, guidelines, that sort of things, to make sure that when there are EU funding provided to Israel, which is lawful, none of those fundings go to the occupied the occupied parts of Palestine. And so this type of measures should be also applied to Western Sahara. And there, the Commission, for us, that's very clear, has two options. Whether they think that that's necessary to remain in Western Sahara to help the political process. Why not? But then they need the consent of the Sahrawi people. So they have to engage with the Polisario Front. If they don't want, for diplomatic reasons or other reasons, to talk to the Polisario Front, they are free not to talk to the Polisario Front. But then they have to leave Western Sahara. And if they don't, we will push them out.
I mean, I hope they are not in Western Sahara and that they would communicate with the Polisario, because they are the representative of the Sahrawis, but then it's emphasized on the decision of the court. Manuel, I have been reading that there is interest in the EU to appeal to the decision of the court. Is that right?
Regarding the technical aspect, this is true that when you have a ruling by the General Court that is like the first instance court within the EU judicial system, there is an appeal that is possible before the European Court of Justice, which is the higher court. Now, on the appeal, there are some things that are interesting to know, is that if there is an appeal, we won't discuss the entire case again. The Court of Appeal will decide only whether the General Court applied properly the law, interpret properly the law. So all the factual background will not be discussed before the European Court of Justice. So the scope, if you want, of the questions are much narrower than during the first instance. The second thing also that you should be in mind is that the Commission or the Council, they will challenge the decision of the General Court, but that will be objectively a difficult task, and they are not presuming on what would be the outcome, the final outcome. I would never do that. But I must emphasize that the two rulings of the General Court are extremely well argumentated, motivated, and so that puts them, the Commission, the Council, objectively in a difficult position, in the sense that the two rulings of the General Court are two strong rulings, if you want. Now, regarding the possibility, so as I say, there is that option of the appeal. That appeal can be lodged by the Council, by the Commission, by the member states that were there, France, but also Spain. And that would be interesting to see whether Spain assumed politically to lodge an appeal against the ruling of the courts, so to betray a little bit more, I would say, the Sahrawi people after the shameless withdrawal from Western Sahara in 1975. So technically, yes, the appeal is possible. Yeah.
Yeah, the last question that I have, and I think we actually have talked about, and that's about private companies. The court ruled out, and we ruled out in our conversation, that companies can no longer use the benefit, or that the local people are benefiting from their business. How does this ruling affect all the private companies that works in the territory and the Morocco contract for exploitation of the Sahrawi resources? What are the next steps now in the legal battle? I mean, you already answered that. Is that you will force the EU Commission if they don't comply with the ruling?
Regarding the effect on private companies, basically, when you are foreign investors and you go to a foreign country, there are two types of things that you can need. Is first one, that's a proper authorization to operate your business by the authorities of that country. Then you can also have a contract with these authorities, providing what are the obligations that you have on your part, the obligation of the authorities. Now, when you have an investment in Western Sahara, all the authorizations are given by the Moroccan authorities according to Moroccan law. But there is a big problem for private companies. Western Sahara has a separate and distinct status from Morocco. Morocco has no sovereignty over Western Sahara. So it means that Moroccan laws are not applicable to Western Sahara. And so authorities given by the Moroccan authorities to private businesses have no value concerning Western Sahara. So basically, those companies took the decision to operate in a legal vacuum with no guarantees at all. That's the first aspect, the first consequence, if you want, of the separate and distinct status of Western Sahara. So Morocco cannot deliver valid authorization to private investors. The second thing regarding the second principle in the consent is that, as I said, there are contracts. And the quote that was used by the court in 2016 and recalled by the General Court in 2021 regarding the consent derives from a principle that we call the principle of relative effects. That is a basic contract law principle that applies to international treaties, but also to contracts. So, for instance, if I decide tomorrow to pass a contract, to conclude a contract with you, the contract will be only binding on us, but we cannot impose obligation on a third party. And so all the contracts that are concluded between the Moroccan authorities and private investors in relation to Western Sahara are wrongful acts because they intend to impose obligation on the Sahrawi people toward their lands, their natural resources without the consent. And I hear sometimes companies saying, well, the court relied on public international law principles, but they're wrong. They relied on a basic contractual principle that exists under German law, Norwegian law, French law, any legal system. That's a principle that we got actually from Roman law that is really at the core of civil law and common law. So we really want to tell to these companies, be careful. What you're doing now in Western Sahara is illegal. Benefits is not a valid excuse. And if we go to court, we'll be able to force you to pay back compensations to the Sahrawi people.
And I think it's more than ever, actually, if I have to be the defender of private companies, that's why it's very important and necessary for the EU and the EU Commission and all to respect the ruling of the court, because that will make it clear for everybody. If, for example, the EU respects actually the ruling of the court, I would imagine that there will be almost non-private companies in the occupied territories of Western Sahara.
You're absolutely right about that. The private companies really use the umbrella of the EU to justify their involvement on Western Sahara using the same narrative about the benefits, the same narrative about the consultation process and impact assessments. But that narrative collapsed regarding the EU. We will be able to push the EU out of Western Sahara. And so does that mean that private investor will stand all alone in the cold in Western Sahara in illegality without the coverage of the EU? Exactly. I don't see that happening. And I remember that in 2015, when we got the very first ruling, Total decided to disinvest from Western Sahara because it was becoming too risky for them.
Yeah, I think we are coming to the end to this episode, and I think you made it very, very clear. And if we have to conclude this in very simple sentence, that the EU court has been very clear on the statute of the Sahrawis in the international law, right for self-determination. They are the owner of their resources. We must have the consent of the Sahrawis, and that's through their representative, Polisario. I mean, the court could not be more clear than this. And then I'm really looking forward to follow up with you and with the EU also.
Just to conclude, maybe a few words about that. I really think that the Sahrawi people have been suffering over the last years, of course, of the occupation of Western Sahara by Morocco, but also of the fact that words were misused. If you want to talk about Western Sahara, talk about Western Sahara properly. There is a Sahrawi people. Western Sahara is not disputed. The Sahrawi people have sovereign rights over the territories, over the natural resources. And the question is only the consent. And so my message is really to journalists, to people getting involved in Western Sahara, but also sometimes to Sahrawis or people close to the cause. The message has to be the same and to be very clear. That must be about the consent of the Sahrawi people. I don't want to see any more press releases referring to the benefits of the population. All the activists must be united, and each company that goes to Western Sahara, they must receive the same answers. Go ask to the Polisario front, get the consent of the Sahrawi people.
Yes, so the consent is our last name now. We have to remember it. Thank you so much, Manuel. I know you are busy, and I'm so grateful that we could have some of your time. And good luck with the legal battle.
Thank you very much for your invitation, and we will keep in touch for the next steps.
Yes, we will. Hvis du vil lære mer om konflikten, gå til vest-sahara.no.